Hi, everybody. My name is Aaron Charfoos. I'm a partner at Paul Hastings, and along with my co-host Ericka Johnson, who will introduce herself in 1 second, we're doing Managing Privacy and Cyber in a Pandemic, Lessons Learned for 2020 and Beyond. Ericka, you want to introduce yourself?
Yes, well, good afternoon, everyone. My name is Ericka Johnson. I'm a senior associate at Squire, Patton, Boggs. I really specialize in helping companies mitigate the risk of and unfortunately respond to cyber incidences of all shapes and sizes. And I'm excited to be here today and to share some of our lessons learned with you.
So during the presentation today, I'm going to start the presentation off, and if you have any questions, please send those directly to Ericka. I won't be able to see them, but she'll be able to ask them. And then when Ericka takes over in the second half, if you want to send a message directly to me, I can ask as we go along, and that way we can keep it interactive. And with that, let's get started. So today we're going to talk about a couple of things. First of all, what's the big deal with the pandemic and COVID and information that we're learning? We're going to talk about the challenge and some data around it. We'll talk about the legal framework, and then I'm going to kick it over to Ericka, and Ericka is going to talk about the risk environment, the rapidly evolving security expectations, particularly ransomware, which is a very hot topic these days, and forensic reports and ediscovery. But first, let's talk about what the big deal is. So COVID has certainly accelerated and upended a lot of pre-existing trends. And for most people on this call, that's probably not surprising. But some things really are really unanticipated with what we've seen. So first of all, what has accelerated? We all know that we've accelerated a remote work and increased reliance on remote resources. Everybody on this call has figured out how to do Zoom, how to share Zoom, how to work from home, how to keep dogs and kids quieter. But there's some things, too, that have been very unexpected. And it's really upended expectations about information that employers might expect from their employees. And we're going to talk a little bit about this in a few minutes. And one of the things that I think that for all of us that we're going to see is that many of these trends are longer lasting than we would expect. I know that our firm, Paul Hastings, is bringing people back into the office starting in July, going through September, but we are planning for years of asking health questionnaires in many of our offices, particularly in densely populated cities. And so we are anticipating that a lot of what we're seeing, not just the remote work, but also trying to gather some more information that was traditionally considered private, will be something that we're going to need to do for the long term. So companies need to really expect that that's going to be an issue and plan for it for the future. And both of those, the accelerated transitions and the upended expectations, will have significant implications for both privacy and cybersecurity, as we're going to see in a minute. As offices begin to reopen, there are a number of dilemmas over what information employers should be collecting. And the challenge really is the extent that the information is truly needed and how best to collect and store it, and then apply state and local mandates on the reporting of positive test results, contact tracing, can you take vaccine information. All of those kinds of things are things that we really just didn't have to deal with before, didn't have to concern ourselves with before, but definitely now, and particularly with large amounts of the workforce coming back relatively quickly, maybe not as quickly as we all went remote, but relatively quickly, that's for sure something we're going to need to think about. And the data is pretty staggering. 76% of organizations have asked employees to notify if they've been diagnosed, something that people generally haven't done. I mean, in many cases, if you had the flu, you didn't have to tell your employer that you had tested positive for the flu, but now those are kinds of things that we're asking about. 53% of employers have asked employees about where their personal travel has been. What states have you gone to? Who have you seen? Where were you? When did you come back? All of those kinds of things. 35% of employers have asked regarding household members' COVID status, and 23% have actually physically taken temperatures of employees as they walk in the door. And particularly, we've seen this in many buildings, particularly here in Chicago where I live. When you walk into a building, there is often a thermal scanner that you walk up to before you can get into the building. something we'd never seen before, probably something that people really would have objected to prior to the pandemic. But now the line goes right up there, it takes a thermal image of your scan, and that's the first step to getting into the building. Some more data. 3 in 10 organizations have been asked to share anonymized COVID data with a third party. That includes a government, researchers, non-governmental organization. And 20% of employers have shared the names of staff that have been diagnosed, and that's either with other employees or with the government. We can talk a little bit about that statistic and how we do it properly in a little bit. 15% have conducted data privacy impact assessments focused on COVID collection. There's a lot more information coming in the door. A lot of people are subject to the European regulations, and even some regulations here in the United States are really assessing how the privacy implications of this need to be dealt with on a case-by-case basis. And about half of the companies have adopted a new technology to enable work from home, and almost 60% of those bypassed or expedited the privacy of security review. And this is something we hear from a lot of our clients. They rush to get everybody out the door. They rush to put in place the critical emergency things that we needed to see to get everybody up and running quickly, and then have really started to double back and now pay attention to privacy and security, particularly looking how that's going to work in the future. So here are some issues to consider. Here's some of the kinds of information that our clients are now getting. Temperature checks and questionnaires. So if your organization is going to start taking temperature checks at the door or having your employees self-report them, think about it. Do you want people to affirmatively give you what they've tested? So if a person tests just sort of the regular temperature, do you need to know what that temperature is? Do you just want to know that they've tested negative, or do you just want them to default to give you the information if they've tested positive to say, I've got a fever today? Who collects it? Are you having a building manager collect it, for example? If you're renting space, do you want the building to collect it before people come in? Some buildings are actually collecting it for the safety of all of their tenants. In many instances, for our clients, if you can have somebody else test for that information, the privacy implications are less because that is information that maybe you're not going to get. And then there's the question of, is it really necessary to keep all of it? And this is one of the most important things that we're going to talk about. We'll talk a little bit more about all the rest of the stuff that we're going to be collecting. But do you actually need to hold that data? That is a really important point that we really are focusing on with lots of our clients. It's great to have an audit trail, but do you really have to have it? Do you need to be getting that information from your employees? Do you need to keep it? If you are going to keep it, how long are you going to keep it? Because if we're just going to get it in and keep it forever, then that in and of itself can cause a number of problems. For testing, if you're going to be doing COVID testing, so like a PCR test or the swabs that you can do of the mouth, when will you require it? Is it going to be weekly? Is it going to be biweekly? Is it going to be every day? And what are you doing with the results? Are the results going to be coming to you, or are the results going to be sitting perhaps with the doctor who's doing it, and you're only going to find out if somebody tests positive? If somebody does test positive, do you have a plan in place to communicate that with the workforce? So in general, what we advise is that it really isn't necessary for you to tell everybody that Aaron Charfoos has tested positive for COVID. If you saw Aaron the other day, you might want to get tested. In most instances, it's probably good enough to simply say that somebody who works on your floor, in your pod, in your office, whatever the case is, had tested positive for COVID and was in close proximity to you, and so you should get tested. So those kinds of questions about how do you communicate with the workforce, and who, if I test positive and I'm on the 45th floor, does everybody else in the building need to know when likely I haven't been in touch with them that often? And we now know from some of the new CDC guidance that you really need to be in a room with people for longer than just maybe an elevator ride in order to increase their risk. So lots of companies are making determinations about how are we going to tell people, when are we going to tell people, and who are we going to tell. And for us, when we report in, are we going to report our diagnoses in using an app? And then how is the company going to get rid of it? So in order to answer a lot of those questions, we have to look at the legal framework. And there are both existing and proposed laws and at the federal level, and there are state laws that we're looking, and we'll talk a little bit about the role of policy here as well. First of all, in terms of existing laws, one of the laws that people think of the most is HIPAA and HITECH. And we're going to talk a little bit about whether or not those are actually applicable, but they are really important to know. So HIPAA and HITECH are going to be the first two. HIPAA is the law that governs the use of information in connection with insurance and with the diagnosis of disease. There are many states that have unfair and deceptive acts and practices statutes. So why are those going to be relevant? Well, along with Federal and State Information Practices Act, those are going to be relevant because in many cases, they require you to explain how, for employees or visitors to your office, you collect, use, store, and delete information. So if you don't say anything about taking information about temperatures and keeping it for the next 3 years, you may have a problem because you haven't properly disclosed under a state law that requires you to explain how you're gathering that kind of personal information. Similarly, if you promise that you're going to delete it and you don't delete it, again, many states would say that you've deceived customers or visitors to your site because you kept it longer than you expected. Of course, for anybody who's operating outside of the United States, the GDPR, and along with other statutes like Canada's PIPEDA, Brazil has a statute that's like GDPR, you have to be very careful because whereas in the United States, information is protected, this kind of medical information is protected, in the European Union, it's protected at a much higher level. So if you have European operations, I'm going to suggest that you keep much, much less information because keeping it requires a lot more in terms of the obligations that you're going to need to follow. I mentioned the fact that HIPAA is often the first statute that people think about, but here HIPAA generally doesn't apply to the information that we're collecting, even if an employer is collecting it as part of a workplace monitoring program, or perhaps particularly because they're doing it as a workplace monitoring program. So HIPAA only covers protected health information, and that must be created, collected, transmitted, or maintained in connection with the provision of health care, payment for healthcare services, or the use in healthcare operations. The EEOC in the United States has said that employee testing generally does not fall within those provisions because what it is actually workplace monitoring. So why does that make a big difference? Well, HIPAA requires a bunch of different kinds of protection that come along with the data that you may not want to have to sign up to. And so, for example, most states will say that non-HIPAA medical information can be stored in an employee's file, but in a separate medical file folder. Doesn't necessarily need to be encrypted, although like other medical information, often it's a good idea to do it because it may help in the event that it's lost. But there are less restrictions around who can touch the data and who can get it, who you have to limit access to. HIPAA is far more restrictive than some of the state statutes are going to be. So it is better to start from a position where you're going to be protecting it as just medical information and not HIPAA PHI. And so that's one of the reasons why you want to be very careful. The place where this often comes up is when you enter into an agreement with a testing provider. So if you're going to be doing COVID testing, most testing agreements that I've seen, and we've negotiated quite a few of these, have said that the information is subject to HIPAA. And so if you inadvertently promise to protect it as if it was HIPAA-protected information, then you may be signing yourself up to obligations which you really didn't intend to do, and so now you've really set the bar high for yourself. So as you're looking at agreements possibly with entities that are going to test your employee population, many of our clients are running vaccine clinics on site. If you're looking at vaccines, think about whether or not you really need to protect that with HIPAA and whether it's HIPAA-covered information. Talk to your lawyers and see whether or not that's something you really need to do. And if the information is lost, and we had a client who inadvertently lost an Excel spreadsheet that had the test results of every employee within the company. And because we had negotiated the agreements ahead of time, such that it didn't say that you had to protect it with HIPAA, we were able to avoid disclosures to the federal regulators because it had just gone to the wrong person. Had we not done that, it would have been a much more complicated analysis. So that's really that forward thinking, making sure you're paying attention to how you're promising to protect the information is really important. In addition to the federal laws that deal with healthcare, and these are really sort of healthcare specific, but we've got a lot of EEOC guidance on can you test, should you test, can you ask for vaccine cards? By the way, we made this presentation really as the vaccines were rolling out and the EEOC was issuing some other guidance. But the answer so far from the EEOC is yes, employers are permitted to ask for evidence of vaccines, and you can take the vaccine card if you want. You can copy the information down, including the person's name, the kind of vaccine that they got. And some employers, and there's a question of whether or not this will be permissible long term, but are even going to keep that information in the event that you have to get a booster shot at some point in time. They will come back to the employees and ask them, have you gotten your booster shot, or reminders about booster shots, or potentially doing vaccine clinics to get people around their time for booster shots. So currently that's permissible, although as we'll see in various states, state laws are starting to clamp down on some of these privacy issues and could definitely change that. We do have a bunch of new laws, and so whatever jurisdiction you're operating in, you should definitely be paying attention to local laws. The slide isn't meant to be comprehensive. It's just meant to give you a sense of what you should be looking for. So, for example, in Kansas, they require participation in state contact tracing to be voluntary and mandates confidentiality and imposes data retention requirements, and it also prohibits certain uses of cell phone location data. This is important because as employers, if you're going to collect the information and then think you need to turn it over to the local authorities if a person tests positive, you may need to make sure that you've gotten the proper employee consents, and that sometimes can happen up front. So if a person is going to get a test and that person is going to sign a waiver form so that the doctor can give the employer the information, you can also include in that form the fact that if local regulation requires disclosure of contact tracing, that you'll do that. So think about those kinds of things ahead of time as you're working with the testing providers or the vaccine providers to make sure that you're able to share the information with anybody who you need to do. New York has some unique statutes about contact tracers being hired by the state health department and representing cultural and linguistic communities of the diversity of the communities they serve. South Carolina actually prohibits local health departments from using mobile apps created for contact tracing. So we're seeing laws all across the board in different jurisdictions, and so it's really important to pay attention where you are to what local laws there may be. And here in the city of Chicago, there are actually some laws being considered that would prohibit asking for the vaccine information. So again, as we move from sort of getting back to the office with testing to getting back to the office with vaccines, we have a whole new set of laws that we might need to deal with that we really have to pay attention to. We also have a series of laws at the federal level that have been proposed, many of which have died in committee and haven't really gone very far, but certainly are something to pay attention to. So the COVID Consumer Data Protection Act, it said that you can't have any contact tracing without affirmative consent. So you have to specifically ask somebody ahead of time if we can do contact tracing. Again, this takes us back to that original question. When you're putting together these programs, make sure you look at everything from the contracts that you have with the testing providers all the way to the consents that you're getting from the individuals, and know what you might need to get consents for later on, because it's really hard once you've gathered the information to go back and ask again. There are also two other Democratic proposals, the Public Health Emergency Privacy Act and the Secure Data and Privacy for Contact Tracing. Both of those laws actually spend a lot of time talking a little bit more about transparency and use restrictions rather than specifically just preventing contact tracing in general. So with that, why don't I turn it over to Ericka, who's going to talk a little bit about what the risk environment looks like.
Thank you, Aaron. Aaron really walked us through what are the considerations, specifically in the COVID-19 environment about collecting data. And he talked a lot about, health-centric data that, you may be collecting as part of your organization, frankly, just to make sure that your environment's safe, your employees are safe. And I think, as he said, this is going to continue to be an interesting, evolving area of law. Where I'm going to talk to you about today is mitigating your risk as you're collecting this data, mitigating your risk of, some type of cyber incident, and then what are some considerations on the back end if, unfortunately, you may be a victim of a cyber incident. And so to kind of do that, we want to really talk about what are our considerations, really in this COVID-19 environment. And so first, I'll talk about the increase in cyber attacks. I'll really kind of do a deep dive into the trends and frankly, what we're seeing right now. It's been quite an interesting 12 to 16 months, and I'm sure many in this audience can really attest to some of the interesting trends that I'll go through here shortly. I'll follow up by talking about written information security plans, WISPs, and while the slide is really focused on what regulators are thinking, I'm really going to try to spend some time about being practical and what it can help for you and your organization to mitigate your risk and frankly be prepared on the back end. Third, I'm going to talk about ransomware, particularly in the wake of Colonial Pipe. And then fourth, I'll talk about forensic reports and some considerations in the wake of two fascinating cases that came out this last year. All right, so really just kind of talking about the trends that we've experienced. COVID-19 has truly increased the cyber incidents that we've seen. And so what we're really seeing is, and one of the trends that I'd like to talk to throughout this presentation is we're seeing threat actors now doing a twofold attack. It's exfiltration of data prior to deployment of ransomware attack or deploying of and encrypting your entire data. And so what we're seeing more and more is this idea of threat actors really using exfiltration of your data as a way to kind of strong arm you into paying that ransom. And why that's really important right now in the COVID-19 environment, as Aaron discussed, is that, we're seeing companies more and more collecting this, type of sensitive data. And, in the United States, we've got a patchwork of 50 plus, every jurisdiction has its own breach notification law. And in every jurisdiction, one of those definitions of personal information is health information. And so by a broad definition, taking people's temperature, things like that, that very well and probably is to be considered health information for data breach notification obligations. And what we're seeing is that threat actors are very smart and they understand that. They understand your industry and they're very targeted. And so what we find is B2C companies, threat actors are using this trend to go after your customers' data, your customers' sensitive data. What we're seeing is in B2B businesses, they're going after your business partner's data, and then they're threatening to say, "Look, if you don't pay us, we're gonna make this public so that your business partners don't want to do business with you," and then just generally, we're seeing threat actors just becoming more and more sophisticated. For example, we had a recent matter where a CFO was tricked into transferring $5 million because what he thought was a CEO was explaining this really complex real estate transaction. And it turns out it was just someone who had, taken over this CEO's account. But I was just blown away that this threat actor was able to speak the lingo. Another example of just being very highly sophisticated, you'll see companies that have, as more and more companies these days are moving from bricks to clicks, they're moving online. What we're seeing is companies that do business online via, online orders. Threat actors are attacking the public-facing website, and then again requesting some type of payment, to release the website. So I mean, all in all, I've got some really great statistics here, but I mean, the key takeaway is that COVID-19 has just continued to push the trend even further. And that we are prior to COVID-19, we saw cyber incidences, and as they come in many different flavors, as I'm sure this audience knows, but we're continuing to see just an incredible increase in the amount of cyber incidences. And frankly, in the demands for ransom, that's been something that I've personally seen a huge change from the request for tens of thousands of dollars now to tens of millions of dollars. And so this is not meant to scare everybody, but it's more to say that cyber incidences are happening and they're going to continue to happen. And unless your organization is thinking about it and thinking about the things that Aaron was saying, do you need this data? How long do I need to store it? If your company is not thinking proactively about that, you're already on your heels. Because the last thing I will say on this slide is what we're seeing with our clients. So many of them are coming to us and saying, well, why me? I'm a plumber in the Midwest. I'm a nonprofit organization that's a health center that's frankly losing money. Why am I getting hit? The reality is these threat actors know that they can exploit money from you, and everybody is a potential target. And so being proactive is just incredibly important, particularly in this environment. Sorry, one last thing I'm going to add to this slide before I go on is what we're seeing is with phishing increase, no longer can, I walk down to accounting or, someone in your organization walk next door and say, hey, CEO, did you really want me to transfer this 5 million? Because we're in a remote environment, it's just so much easier for these threat actors to exploit us using social engineering attacks, essentially where they're taking over someone else's account, they're purporting to be someone that they're not. And in doing so, it's generally we see like a request for a wire transfer, because my bank account has changed or because we need to do this deal. Because of the remote environment, it's made it easier for, the Nigerian prince to just suddenly become so much more effective. And that's really the environment we're in. Okay, and please let us know if you have any questions along the way, and make sure you just send them over to Aaron. He'll bring them up as we go. All right, so the rapidly evolving security expectations. So I talked about in the last slide, WISPs. So just kind of broadly to back up, a WISP is really your playbook. It's your game plan. It's a document that sets forth, what security protocols that you have in place. It sets forth what's your incident response plan. It can set forth what's your disaster recovery plan. It essentially is your playbook for in the event that you have, some type of cyber incident. And what I say here is that, yes, it's important that regulators are now expecting it more and more. For example, if you go and report a data breach in Massachusetts, it forces you to answer the question, do you have a WISP? Do you not have a WISP? But I think the key here is that if your desire and drive to have a WISP is because of regulators, I think that's the wrong perspective. Based on my conversation on the last slide, the inevitability of a cyber incident is, and it can be big or small, but it's likely. I get 3 to 4 phishing emails a week and it drives me nuts, but I screenshot them for these presentations so I can do them later and I get kind of excited about it. But the reality is the likelihood that your organization is going to have some type of cyber incident is high. And so it's important that you really take the proactive measures to ensure that you guys are prepared. And one thing I love that Aaron said is think about what, he talked about specifically in collection of data related to COVID-19, but this is a good opportunity to say, okay, well, what other data do I have out there? What other data, we recently represented a university and we had data back to like the 90s, and so it's thinking through, understanding the data you have. And I would strongly recommend, I'm not going to go in detail here, but do a data mapping exercise, understand where your data is. And then as you create your your WISP, as you create that, the value in that is thinking through what security controls that you have in place, working with your IT team. And one thing I say is that this is no longer an IT problem. This is an everybody problem. And if we put the onus on IT to just kind of protect everybody, it's just not effective because it's got to be a team effort. So your plan's got your internal controls in place. It also has your incident response plan. An incident response plan is literally your break glass here. This is what we need to do. Your plan basically walks through what would you do in the event of some type of cyber incident. It's really important because—
Hey, Ericka.
Yeah.
We've got a couple of questions in the chat before we go too far down the road. Can you remind everybody that what WISP stands for first?
Yeah, Written Information Security Plan. I'm sorry. I'm sure I've botched that like 5 times.
No, it's good. Second question, are you seeing specific written information security plans that are more COVID related? So, companies may normally have a WISP, but do they have like a specific rider for COVID related issues?
I have not personally seen that myself. I think that's absolutely a best practice. But what I'm normally seeing is that someone has written one 3 years ago. It's dusty on a shelf, and we like blow it off when we say when a regulator asks about it. And so, I mean, I think if someone's asking the question, is it COVID related? That makes me happy because it tells me that they're already thinking that they have one and they need to update it. So if that's your perspective, that's great because I could tell you're way ahead of the game on most of our clients.
And last question, and I'm pretty sure you're going to give a lawyerly answer on this one, that it depends.
Okay.
Are there any current legal penalties for businesses who experience breaches? And they use the example of paying fines.
Oh, say that again. I'm sorry. What was the question?
Sure. Are there any current legal penalties for businesses who experience breaches and, for example, paying fines?
Oh, well, I'm glad you asked that question. So, paying fines specifically, I may have to get back to you on paying fines. I just don't know that off the top of my head, but I will say that
it probably depends on the jurisdiction.
Well, yeah, it definitely depends on the jurisdiction. I was going to say in 3 slides down, I really talk about civil penalties in the context of ransomware payments. But for just, having a breach itself, it definitely depends based on the jurisdiction. What I haven't seen that in the context of regulators, but what I have seen is just a lot of inquiries and a lot of headaches for clients. Just asking about what you've done beforehand, what you're doing now. And really what I've seen, our regulators are less focused, in my experience, and fines, and they're more focused on making sure that you've remediated and really getting in the weeds on, what you've implemented going forward and how you're going to mitigate your risk going forward. I will say that it definitely does happen. At Uber, we've had some sizable examples of attorneys generals go after bigger companies. And it's generally in the context when they fail to report and they cover it up. And then that's when they do get penalized. So yes, they do. It depends on the jurisdiction. But Uber is a good example of it. And I'm really struggling right off the top of my head of some other good examples, but I know there have been some big fines, but all of those were in the context of failure to report, and intentionally, kind of covering it up. That's really been the examples.
Well, and I think that on top of that, there are some things that are not fines, which are still pretty painful. So if a regulator requires you to implement a written information security program and then audits it, and then comes in every single year and audits it and has to approve changes to it, that can be really challenging for a business. But where we see a lot of the commercial penalty, I wouldn't necessarily call them penalties, but is often in data breach litigation where individuals may be coming after in a class action, or where other companies, if you're a processor of data for another company and you cause a breach, if you lose their information, you actually have a commercial risk because they may have a provision in the contract which requires you to have certain security standards, and people can say that was a violation of that. But like Ericka said, oftentimes one of the biggest costs is just the remediation of the whole thing.
It's a great point about litigation. Yeah, absolutely.
So there's another question here. Is there any case law where penalties were lowered if an organization that was breached was ISO 27001 certified or SOC 2 type audited?
We're going to have to take that one and go back and do some research on that. I just, unless you know, Aaron.
What I would say is I'm not sure that there's case law, but there are plenty of jurisdictions that require reasonable cybersecurity.
Oh, yeah.
And so the question is, is it reasonable to have those? What are you protecting and how are you protecting it? They may provide some defense to the fact that it wasn't reasonable, but it's not. Some jurisdictions, for example, will say that if the data was encrypted and the encryption key was not stolen with the data, it's kind of a get out of jail free card. You're fine. You don't even need to notify. I don't know of any jurisdictions which give a similar get out of jail free card for ISO or SOC 2, but it can definitely help in the defense.
Yeah. Okay. Any other questions before we go on? Okay. Thank you, guys. These are great questions so far. Okay, so now we're going to kind of transition to ransomware. And I really do think that this is timely. We didn't, obviously we didn't anticipate this when we created the slide deck a couple months back, but, I find interesting with Colonial Pipe, my takeaway from that was, it really, I think it shows the everyday American, the reality of, and the impacts of ransomware attacks. I was listening to a news broadcast, and the anchor said, "Oh, well, we hear about these ransomware attacks every 2 or 3 months. It seems like it's becoming a problem." And as somebody who is in incident response every single day, I thought to myself, well, is that what the American public thinks? Because we actually see these things every single day, and it's just not a matter of if, it's a matter of when. And so kind of what I talked about earlier on these key tactics of these bad actors with ransomware, I would say 3 years ago, we just saw threat actors coming in, infiltrating the environment, destroying the backups, and then encrypting the entire environment. And that was the MO. There was no access. There was no exfiltration of data. But it's just significantly changed. What we're seeing more and more is that these threat actors are exfiltrating data, and they're doing a very good job of covering up their tracks on the back end. Like, you'll be able to see that they're exfiltrating data to, for example, like an AWS a bucket, that's what they're called, or to some other third-party website, but you won't be able to see what's been taken. And so they're very good to let you know enough that data has been taken, but you just don't know the full scope of it. And that's part of the negotiation is, you pay for us, we delete the data, we tell you sometimes they'll tell you what type of data was taken. And what I'm seeing more and more clients who are actually paying just not because they need the encryption key, because people have gotten more savvy about backups, but paying for the data to be deleted. And I think for somebody else who mentioned it, it's because of the litigation risk, Okay, so what we saw, as I said earlier, is under COVID-19, we're seeing an incredible increase in ransomware attacks, and the government recognized that. And so the Department of Treasury, two of their agencies, the Office of Foreign Asset Control, OFAC, or Financial Crimes Enforcement Network, FinCEN, they both issued an advisory on October 1st, the exact same day, and they were parallel advisories. And essentially what they both said is that we're seeing an increase of ransomware attacks. And so we just want to restate what the existing law is. And I'm completely paraphrasing here, but essentially the existing law is you cannot pay funds to people on this designated list. And I always mess up the name, so I wrote it down. It's the specially designated nationals and blocked persons list. And it's essentially a list that it's a sanctions violation if you pay people who are on this list. And it didn't say anything new. It just said that it just was kind of a reminder, look, you victims of ransomware attacks, those who are involved in this, to include cyber insurance companies. So as many of you know, most of these organizations now have cyber insurance. And so what it raised the kind of the red flag of, hey, just so you know, just so we're all clear, we cannot be paying people who are on this designated list. And OFAC puts people on this list. They put cyber criminals on this list. And so, I think it was part enforcement, just trying to say, look, we're really trying to make, a push to show that we're putting people on this list. Please don't pay those people. And it really just restated existing law. And existing law said that if you pay people on this list, there's a presumption, strict liability, that, you violated the law, and, you have to, there's a strict liability for the civil penalty for doing so. And so what I found interesting about that is it didn't really change anything that we did. From a practical perspective, if you've got a client or, as an organization, you want to pay for a decryption key or for the promise to delete exfiltrated data, you do an OFAC check. That was something that we always did. But some of the key takeaways because of this is now OFAC checks are very thoroughly analyzed. We clearly document them. Generally, you'll have an attorney on your team that's part of your incident response team, which should be part of the team that you've created ahead of time in your incident response plan. You thoroughly document that, and you have a written memorandum from your attorney saying, we've done our due diligence. Generally, use a third party to do an OFAC check on them. And then another thing that we've done as a result of that with our clients is, we have them go look at their cyber insurance policy now and say, sometimes there'll be indemnification if, for example, you pay this ransom and it turns out, they were on the designated list, you're fined, then you could try to turn to your insurance carrier and try to receive, or you're indemnified for that. As a practical matter, though, what we're seeing is that insurance carriers are so much more involved now. Their due diligence is, because generally if you're going to pay the ransom, you need to get the approval from your carrier. What we're finding is carriers are so much more hands-on. They want to read the OFAC check report. They want to make sure everything's good to go because they understand that they potentially could be on the line as well. And then a third thing that we've really taken from this and kind of a lesson learned is just as part of your incident response plan, because if the regulator does ask, for your WISP, that you have in there, make sure as part of your check mark in responding, make sure you're doing an OFAC check. So that's just showing regulators that you're focused and you're aware of the law and you're complying with the law. Now, finally, a key takeaway from this is if you think you run into a situation where you may have made a payment, and you shouldn't have, the alert basically says, look, we'll give you leeway if you're proactive in letting us know. That's something that they'll take into consideration. And so really all this did was just let everybody know that this law is existing. And really the key takeaways we've seen is that the due diligence has to be much more on the OFAC check. Cyber insurance carriers are much more involved in any ransomware payment. And we're just more thorough on this step. And we've always been thorough, but we're just even that much more thorough.
Hey, Ericka, I have one question and actually a helpful follow-up from some people in the chat. Yeah. First question, nobody's asked this, but lots of people I'm sure are thinking about it. How many of your clients actually pay the ransomware?
I'm so glad you asked that. It's a mixed bag. And it really, so some considerations are, I have some clients who are just like, I don't care, my company will go under before I pay these threat actors. And it's a moral stance that they take. And so that's kind of one bucket of individuals. Another bucket we've seen is those who are so terrified of the data that's been exfiltrated that they're paid just for the deletion. So oftentimes we've gotten really good about having viable backups. And so that's less of the issue, but you'll have clients who pay because they're worried about, all the sensitive data that may have gotten out. And so that's another clear trend I've seen. And then the third trend, I think this really runs into Colonial Pipe, is that you feel like your hands are tied. Your data has been encrypted. You don't have a viable backup. You haven't had a WISP. Well, I don't know in that case, but clients don't have a WISP. So one thing they haven't thought through is, well, what's our disaster plan? How do we move to manual processes? And they just can't fathom moving forward. And so then they pay for it. And so those are really the trends that we see in those who end up paying.
And just as an update, thank you to Stephen and Stephanie. Stephen pointed out that Ohio actually has a statute, Chapter 1354, on businesses maintaining recognized cybersecurity programs. It provides an affirmative defense So that generally means if you're sued after the fact, you can use that as a defense against the breach. Again, it's probably a little bit different than an encryption, because encryption would preclude you from even notifying anybody about it. This is afterwards, but it's a great point. And Stephanie said that both Utah and Connecticut have recently enacted or introduced litigation with those similar kinds of issues. So thanks to everybody.
Absolutely. And I think what that really does is highlights the nuance in all 50 of these U.S. jurisdictions. And many of our clients are not just U.S. focused. They've got operations in the U.S. and Africa and Latin America and the South Pacific. And so it does get very nuanced very quickly. And I'm glad you guys mentioned that, because even some jurisdictions, I'm working on a matter now, sometimes you can't get all of the addresses. So you have to do substitute notice. Well, sometimes in some jurisdictions, if you have relied upon your incident response plan to the extent possible, it precludes you from having to go through some of these bigger steps for substitute notice, which usually is like notifying the media, putting on your website, a lot of other steps. And so there's no downside to having a good WISP. That's really the key takeaway.
Another question in the chat while you were talking: how can companies confirm deletion of exfiltrated data if that's what they're looking for?
Yeah, you have to rely on the threat actor says. You can't, and so often what we do is we work with a vendor that has like dark web monitoring. And so they will, for a period of time, they'll go out and they'll use their zeros and ones algorithms. I'm not the zeros and one person, but they'll go out and they'll see whether or not, and they'll go on these threat actor shame sites and see whether or not there's any evidence of the type of data that we would have expected. And in my experience, we've never, we haven't seen that we've paid. I've never seen we've paid and it didn't work out. And that's not to say that's the case for everybody, but their business model is trust us, pay us, it'll all go away. And if word kind of gets out that you can't trust them by paying them, it kind of negates their business model. So, but I think a lot of people in this room know that, Colonial Pipe, paid $5 million for the decryption key. And I really hate the mischaracterization of it didn't work, because oftentimes you'll get a key from the threat actor and it's not as efficient as you'd like it to be. Oftentimes it'll, instead of just decrypting one file, it'll keep the decrypted file and then it'll create a whole new file. And so it's just slower. And so some companies that need to get it back up faster, they find manual ways around. But the decryption key, in my experience, has always worked. It's just maybe not as fast as people would like it to be.
And just to add to that, I mean, one of the things that we've heard in conversations with the FBI or the Secret Service as we're working through some of these incidents, we've actually heard that Ericka, as you said, this is a business model that is based on trust. If the consumers, who are those of us who get hit with the ransomware, no longer trust that the hackers will unlock, it will actually be a problem, because then the whole thing unravels. There's actually evidence that in the cases where hackers didn't unlock it, other hackers have attacked those hackers as retribution to really threatening their business model, and a very lucrative one too. So we do see that there is almost some weird self-governance in the space where the hackers are making sure that people are undoing it.
And their customer service gets very good once you've paid. It's pretty amazing. They're there for you to make sure it works. It's quite fascinating.
And to help you buy cryptocurrency and get it to them too.
Yeah. Oh, good.
800 numbers and all.
Yeah. It's a pretty interesting business model, and I don't know. Just to get a quick tangent here. I know, President Biden, he implemented his new executive order. And, I think it's going to be helpful, but I just want to know what the long-term plan is for companies like people in this room. It's at the end of the day, you guys are protecting your own infrastructure, and so I don't know. I just really hope we come up with a big solution. All right. That's the Marine in me coming out. Okay, so let's go ahead and now turn to forensic reports and ediscovery. This, over the last year, I guess, so June was the last first case. So we had the Capital One breach come out, a case came out, and then the Clark Hill matter came out as well. These are both two cases that really focused on whether or not the forensic report was discoverable. And let me back up a little bit, and I apologize if you guys already know this, but a forensic report is a report created by usually your IT forensic team that you retain, for this incident. And what a forensic report does is it details your the holes in your holes in your plan, how the threat actor was able to get in, the date that they were able to get in, what data they were able to access, what data they were able to exfiltrate. It really is, it's a document that basically says how you got hacked, and frankly, why you got hacked. And so during litigation, plaintiffs, of course, they want this document because they want to know how, were your security measures in place reasonable? That's usually what it turns on. And so this document is so important to really understand the nature and scope of the breach. And so it's always really hotly contested. And so matters that have the potential to go to litigation, these two cases really say a lot, and it's a very evolving area of law, but these have been our most recent cases, and interested to see how this continues to evolve. And so I'll kind of talk through what were the key takeaways from each of these cases and a little bit about them. So the Capital One breach, I think many of us know, I think the threat actor was a woman from Seattle, I want to say, or something like the Northeast. I'm sure someone in chat knows much more. But essentially there was just millions of customer data that was potentially exposed. And so in this case, they brought in, they retained an outside counsel, and outside counsel essentially re-retained their existing IT forensic vendor, Mandiant. And so the court in this case said, look, this report was not created in anticipation of litigation. It was created for business purposes, and therefore this forensic report is discoverable. And so let me walk through some of the key takeaways from this litigation. Number one, to maintain attorney-client privilege, you really want to make sure you work with a vendor for which you have no pre-existing relationship. So in this case, they work with Mandiant. They had a pre-existing MSA, a pre-existing statement of work. And what the court said is that, how can you anticipate litigation if you've already kind of come up with what you're going to do ahead of time? And so the court said, hey, look, that was not anticipation of litigation. And so for us, as a practical matter, we ensure that if the client does have an existing IT service provider, we would like to bring in our own third-party forensic team, because it's really about creating a report in anticipation of litigation, helping the attorney. And as I go through this list of five rather, just know that it's about the totality of the circumstances. It's not one of these really is game-changing, but I'm going to go through what best practices are. The second thing is what I just said is retain a second firm. If you generally you'll have either your own in-house IT firms or a third-party IT service provider. It's always best to bring in somebody new, so you could really make the argument that we brought in these new guys and they're solely focused on litigation and not, we're not just recycling the old team in here who's already been involved. As a practical matter, your IT service provider, you're going to be very involved with. They know the infrastructure. They were probably there to help you respond immediately to the incident. They're going to be involved. I'm realizing now that we're just about out of time. And so let me just run through the list really fast. Number one, have no pre-existing relationships with your IT security team. Always best to retain a second one. If you have to use your existing IT service provider, create a new statement of work, and don't just recycle your old one as they did with Mandiant. Use your report only for litigation purposes. In this case, they shared it with like 50 plus employees, their accountants, regulators. So don't do that. Only provide it to in-house as much as possible, and then pay for it out of your litigation budget. Clark Hill basically affirmed Capital One, but they had a few nuances, and really their nuance was, if you're going to provide your if you're going to provide the forensic report to anybody, provide it, focus only on your in-house counsel, because in that matter, they provided to the IT team, leadership, and the FBI, and they still said, well, that's still for business purposes. That's not anticipation of litigation. So minimize who you're providing it to, and don't have any of your recommendations for bettering your IT environment in that, because that's more business. I apologize that we had to race through this last slide. I lost track of time, but these are, if you're in the situation where you are going to do a forensic report, make sure you're with an attorney that understands the nuances of these two cases, because they really do set the groundwork for what you need to know to mitigate the risk that this will be discoverable during litigation.
Hey, Ericka, there's something on here that I want to re-emphasize for everybody too. Mm-hmm. Don't write it down. I mean, there's so much that we can do with just talking to the forensic experts, having them talk through things. And it's hard. We get it. We understand that if you're a regulated industry, sometimes you got to do a root cause analysis, and the engineers want to figure out what's going on. We understand all of that. Yeah. But at the end of the day, so I'm a trial lawyer, and I can tell you that trying to piece together a trial with bits and pieces of deposition testimony from one person to another is one thing, but having a 150-page report which explains absolutely everything that went wrong with the company is an entirely different one. Don't write it down. We can get around the written requirements in almost every circumstance.
Our clients who are litigation is likely, we do the same thing.
Yep.
Okay, so recap, we really went into reopening protocols, collection procedures, and then what to really think through to mitigate the risk of that data and other data, potentially being exposed during some type of cyber incident. Thank you guys so much for your time. I'm sorry we ended up going fast at the end, but we're still available. If anyone has any questions, we can stay on for a few more minutes.
Yeah, I think we got a couple minutes left for any last questions. Looks like maybe not.
Okay.
All right. Well, thank you, everybody. We really appreciate you taking the time to spend the time with us. Thanks, RSA, for letting us speak, too.
All right. Thank you.
Bye.